Now to the courts. The bail bid by accused number 2 in Meyiwa's trial is still undecided. Bongani and Tanzi filed the application in October of 2022. 4 months later, the decision on his application is still pending. Tanzi is the only one out of the 5 accused without any previous convictions. Our senior reporter Silindelo Masikane earlier spoke to the lawyer who made his application and other legal experts on the matter, and she joins us now here in studio. Now, Slee, perhaps just take us back to that bail application itself as a foundation for this conversation.
Now, you'd remember, of course, that we are in the middle of the Meyiwa murder trial, where we do understand that 5 men have been accused of his murder. And of those five men who've been accused, Bongani Tanzi is accused number 2. And he was arrested, in fact, when he was still at work. And during his arrest, we understand he claims that he was never given an opportunity to apply for bail. And so at the time, he was being represented by Titi Tobane, who at the time, in fact, was representing 4 of the 5 men who are accused. He then proceeded to launch a bail application in the middle of a trial to try and get Bongani out on bail because according to his papers that he filed to the court, he's got no previous convictions. The only pending case against him is this one of the Meyiwa murder trial, and he's the breadwinner in his family. In fact, during those bail proceedings, we heard from one of his family members who said that his family desperately needs him to come back home so that he can try perhaps to make some ends meet for the family. And this was back in October 2022. We're 4 months in, and there's still been no decision that's been made. And so we know that Ntanzi has now released the lawyer who had made the application from actually representing him. But Tobane, of course, being the lawyer who had launched the application, he says that he has written to the court to try and understand exactly what the delay is in terms of this decision having not been released 4 months later. Let's take a listen.
A reasonable person will assume that between 14 days and 21 days is reasonable, and we have been waiting for the judgment. We did send a letter to the Honorable Court, and the officer was handling the bail application. Up to so far, we didn't have a response.
Now, Asli, what are the experts saying? Is it normal for bail decisions to take this long of a time to be delivered?
Not according to the legal experts that I've spoken to. In fact, they find it quite strange that it's taken this long. They're saying usually bail applications are treated as urgent, like an urgent application where you are expecting a decision in the very least within 2 weeks or 20 days or so. So they're saying that this extended period is quite peculiar. We had an opportunity to speak to Alton Hart from the UJ Law Clinic. This is what he had to say.
I mean, it's strange because bail is not supposed to be seen as a punitive measure, but a matter of interest of justice, so that a person can actually properly prepare and conduct his or her defense or trial. And it should not, because now it seems like this person is being punished because the bail application was done, and 4 months down the line, there's no decision pertaining to is bail granted or denied. Of course, we need to have some clarity.
Lastly, here's a name that seems to keep returning in relation to this trial. It seems disbarred advocate Maliselo Tefo has written an affidavit to the court. What's the latest regarding the trial itself?
Now, you would remember we had our last sitting in November, and that particular sitting, in fact, we were expecting the state's 3rd witness to take to the stand. The 3rd or 4th witness, sorry, Marcel, it's been some time, but we were expecting a new witness to take to the stand, and all of a sudden, we had a new lawyer who was going to represent accused 1 and 2, which meant that the trial had to be delayed for about 6 months. So the next sitting will be in May. But now I have received an affidavit that disbarred advocate Maliselo Tefo, who was representing accused 1 to 4, but then took himself off the case. He's written an affidavit essentially accusing some very high-ranking officials of a conspiracy to cover up what truly happened on the night Meyiwa was killed. In fact, many of these allegations we've heard from Tefo before. and he is actually requesting that counsel as well as the accused come back to court sometime next week. And we had some analysis in terms of the significance of this affidavit, if anything at all, because as you would know, with Defo being disbarred, he is no longer a lawyer or representing any of the accused in this matter, which begs the question, what is his interest still in this matter? But then we spoke to one of the legal attorneys in Pretoria, and this is what he had to say with regards to how the court may treat this affidavit.
We know that Defo has withdrawn as the attorney of record or the counsel on record. So he's got no locus standi, no right to appear before the judge on behalf of the parties because he's not their lawyer anymore. Number two, he can't be their lawyer anymore because he was stricken from the role of advocate. So whilst that happens, no judge will allow him to be heard. So if you don't have locus standi, you are not representing the parties. On what basis are you actually trying to have an audience with the magistrate or with the judge? Now, if you have to look at the letters, Lee, the interesting thing is he wants to introduce peripheral issues. Essentially, that should be ventilated to the attorney representing the accused, and that he should decide as the legal representative of those 4 or 5 accused whether he wants to make use of that information and whether it's useful.